This matter pertains to the doctors who are serving under the state of West Bengal. Now, my lord, they are aspirant to take up fresh employment under the AIMS authorities. Now, my lord, for that they have applied. Now, the recruitment procedure, it states that those who are working under the state of West Bengal, they are required to submit a no objection certificate from the state of West Bengal. Now, my lord, they had approached the learned tribunal saying that by the precedents which have already been set by this honorable court, that we are allowed, may be allowed, and we may be permitted to give and get the NOC. Now, my lord, the tribunal, without deciding the matter, has abdicated the matter afresh to the authorities to pass a reasoned order. Now, my lord, I have come up before this honorable court. After that, they have passed a reasoned order saying that we are rejecting it. Now, my lord, your lordships have been pleased to decide the issue that once a writ petition has been filed, but after that, if you file a reasoned order, that becomes an honest in the eye of law.
There is a judgment.
Your lordships have passed it, my lord.
I don't remember. We don't remember saying anything like this in any judgment.
Now, my lord, what has happened? What has happened in the meantime? My lord, the time is coming up that I have
The judgment that you are referring to, the facts were totally different. The state had rejected the doctor's claim for resignation by saying that there is a paucity of doctors. That reason was substantially upheld by the tribunal. After accepting that reason, it said still you consider whether doctors are sufficient or insufficient. Then we said that since the order is in continuation of the tribunal's order and both are required to be challenged, therefore we took up the writ
My lord,
petition.
that was one
That
set.
we didn't say that because an order has been passed, it is honest in the eyes of law. There's
My lord,
no.
that is one set of the decision, and another set, my lord. Here the same issue came up. They are again.
If there is a subsequent order, then how it can be taken up by the court directly?
My lord, we had filed the writ petition prior to this.
So what?
My lord,
Now there is an order which is not before the tribunal, then what can be done?
my lord, may I just place the case, my lord?
You may.
My lord, may kindly catch up any day in the coming
Monday.
My lord, may I mention one urgent matter, my lord, for upgradation of the matter, my lord. It is item serial number 30.
30.
Item serial number 30. 30. My lord, this important matter, my lord, heard several times. The settled issue.
So 30 you are in, you are mentioning.
Yes, my lord, I am suffering contempt petition. My lord, my GM has been directed to appear before
When?
the tribunal. My lord, I have mentioned it is last.
When he has been directed to appear? On what date is his appearance fixed?
Yes, my lord, I am telling you one. This is the order, my lord.
Oh, sir.
87.
87.
87.
Yeah, all right. You wait. Yes.
My-
Don't underestimate us so much. Item 30 and you have the matter is fixed on 8th of July.
Yes, my lord. Yes, my lord. I am
We are not so slow. I don't think so.
No, my lord.
Your friends will tell you.
Actually, what happened, my lord, already they have directed to
Why are you mentioning, sir? Why are you mentioning?
because it is
Yes.
hanging for
Call the list. Call the list. Give the inclusions. Please give. Don't mention. You can give the.
I have also filed an application for early
Sir,
hearing of
you
the-
be ready. Probably on Monday, your case will be most probably. Let's
Monday. Oh, I'm
most
so-
probably.
I'm
We are not accepting your slip. Yes.
I'm deeply obliged. Deeply obliged, man.
If not today, we don't know.
May I be permitted to mention one matter? I am representing on behalf of the Bar Association City Civil Court. There is a hurdle for car parking.
There is a
There is a get problem of car parking.
in city civil court,
Yes.
and you are mentioning here.
Landed Chief Judge City Civil Court. She was advised. Your Lordship is in charge of the City Civil Court. That is why I went.
I am not aware.
I went to the office of the. I went to the office of the, and she advised.
No, sir, I am telling you, I am not aware. I am not just saying like that. Yes, call the list.
Item number 1.
What to get into that? Here I find anybody. AFT matter. What is it? Disability pension.
Covered by your lordship judgment in previous judgment, your lordship has stated delay and on the ground of delay and pendency of the matter before the Honorable Supreme Court, broad binding.
We have decided this issue.
No. You have granted stay. Interim order has been scared. No opportunity of filing affidavit in opposition was given.
Oh, where is the order? Can we see the order, please? No, sorry, it is. January 24 order.
January is the 24 is the review order, madam.
So the main order is even earlier. You are filing a writ petition after 1.5 years and you want stay.
This
1.5 years after the review.
January.
11th day of January 2024 at 2:30 p.m. Review was disposed of. That means the main application was even prior thereto. 1.5 years later, to serve copy, then come back.
Sir, they should have noted.
File an affidavit of service, take steps, come back, we'll see. Let affidavit of,
Item number 2.
My lord, I'm for the petitioner, my lord. My lord, my submission will be based on a simple logic. In a government organization, the attendance register is static document and remain constant during the existence of that organization, my lord.
can you use the mic, please?
My lord, my submission is in a government organization or whatever may be, in an organization, attendance register is a static document, my lord, remain constant during the existence of that organization also. My lord, what has happened here?
Attendance register is a constant document. What else?
Static document, my lord.
Yes, static
Static
document.
document remain constant
Yes.
during the existence of that organization, my lord. What has happened here, my lord? Here, the petitioner found in the pandemic period of the COVID-19, 62 days deficiency of the childcare leave. She made some correspondence with the respondent number 5, and the respondent number 5 suddenly passed an order and deducted 9 days early. My lord,
Oh, your matter is pending before the tribe.
Yes, my lord.
Why have you filed a writ petition?
Expeditiously, my lord, the
Sorry,
same thing is
no, sir,
pending for 2 years, my lord.
we don't know. The writ.
Recent order and to add and to update the leave account.
Correct, for some.
Item number 3.
Allowing for the petition. I am for the petition. This is a affidavit service. My lord, petitioner, my lord, got appointment on compassionate ground on the death of her husband. Thank you. Yes, and my lord, accordingly, she got the appointment in the post of peon in Group D staff in respect of a particular Gram Panchayat. My lord, thereafter she retired, and after retirement, she approached the land reforms department, authority district land reforms officer for grant of her pension. But the authority, my lord, did not take any decision. Accordingly, my lord, the petitioner in the first instance approached before the learned administrative tribunal in 2022. But 2022, my lord, in terms of the order passed by the learned tribunal, the additional district, my lord, additional secretary, land and land reforms department consider the my lord, prayer and rejected on the ground. My lord, there is a DCRB rule 32. There is a my lord, there should be my lord, 10 years of my lord, service, but there is 2 months 13 days my lord, shortfall.
Only.
Only 2 months.
Where is the order? Show us.
Yes, my lord, page 53, the order passed by the additional secretary, which is challenged before the tribunal, page 53. Though it has not been my lord, clarified, simpliciter rejected my 53.
So where do, it doesn't say 2.5 months.
No, certainly not. My lord, it should have been, but if you also kindly have a look the tribunal's order, my lord, it has been, my lord, stated before the tribunal that there is a, my lord, kindly come to page 58. 2 months, 13 days.
What is your case, sir?
My case is
What is your case? How many days or months are deficient?
months.
Where have you said in your
My
application?
lord, the order itself, it has.
Where have you said in your OA or the writ
Yes,
petition?
my lord, my lord. I have. My lord, paragraph number 6, my lord,
Of the OA?
7 way, page 5. Right. 6, 7.
What is your date of joining?
My date of joining is issued appointment letter on, my lord, 13/7, 15, my lord, page 47.
13/7/2005.
Yes, my lord.
And when did you retire?
My lord, I retired from service, my lord, 11/7/2025.
11/7/25.
My lord.
And you are saying there is less than 10 years. How it can be 11/7/25 is just day before yesterday.
My lord, Superintendent, my lord, sorry, 3/3/2024. Sorry, my lord. 3/3/2024.
3/3/24.
24. With effect from, my lord, 30/4/2024.
3/3/24 with effect from 30th/4.
My lord, kindly come to phase 48. Order of the release order, Shobita Mondol is
The basic fact that you are required to inform the court, you are still grappling with that fact.
no 30th/4, 30th April.
How can there be a retirement of 13/3 with effect from
Sorry, my lord,
34?
2015.
Say anything.
30th April 2015. Well,
Far-fetched.
apology, my lord.
Totally. What is the date?
And see page 46, initial appointment letter.
Basic fact you're not able to tell the court.
Appointment made on constitutional ground.
11/7/2005.
Yeah.
Yes, so she joined on 13/7, 2 days after that.
Vacancy occurred on 13th October 2003.
Hmm?
Vacancy occurred because there must be a vacancy.
Hmm.
Vacancy occurred on 13th October 2003 and one appointment letter.
13th October
2003, page 46. Serial number 2.
page 46. And what is the date of retirement?
Is 48. 30th April
30th April 2015.
2015.
30th April. Yes, now it is clear.
Joined on 13th July 2005.
So less than 3 months.
2 months, 13 days.
But only when the file was sent to the government, finance department. That
No, what is the rule position? We have already decided this issue.
issue? You actually directed the department to government to consider what should be the guidelines.
Yes. Where is that judgment?
Haradun, my lord's judgment, my lord, Haradun Mahato, it has been, my lord, decided that, my lord, there is shortfall of more than 3 months. That was condoned by, my lord, the division bench of this honorable court, my lord, in Haradun Mahato's judgment. I'm the WPS to the judgment.
Court judgment. Haradun Kumar, court judgment.
Haradun Mahato, Haradun
And what
Mahato.
the tribunal has done, let us see the tribunal's order.
Kindly come to page
Tribunal's order.
58.
Page
Tribunal did not decide the legality and validity of the order passed by the only, simply stated relied upon their decision. Page 58.
Yes. We should process. Not doing anything in the case.
Yeah, please.
Must be, yes.
Matter was referred to the finance department. Finance have decided at page 64A, 5th March 2025. But this order was not challenged.
18-124 is the rejection.
Finance order was never served upon us. Only, my lord, it is a departmental communication between land department and finance department.
The order is 18-124.
5th March, can you see page 64?
64.
Yes. This order was not challenged before the tribunal.
64 is a
64 is a type copy.
This document was submitted at the time of hearing, before the pendency of the matter before the tribunal.
So therefore you are not required to challenge it.
I require, but I have challenged the order of the additional secretary that where from it appears the final
And if it is set aside and this order remains, will you get anything?
before this read petition. I have challenged that order also.
Can you do so directly before the High Court?
Certainly not, my lord, but I could not get any chance, my lord, there.
You are responding to every query, but you know what you have to do. You are unnecessarily responding to every query.
If your lordship again have a look into the, my lord, the page 53, the rejection was on the basis of the finance department.
If we set aside the order, can you get anything? Again, we are asking.
Yes.
You may continue to argue all day.
I know, my lord.
You know, therefore we are again and again asking you. What do you want us to say? Tell us. Why should you file such a writ petition? You must have seen it at the time of filing. Not only you have filed it, you are arguing, and when you know what is the fate, still you are making.
Learned Tribunal, my lord, has taken this, my lord, memorandum, the office order, my lord.
Why not? It should. It is not a challenged order. It is relied on it. What is wrong with the tribunal's order? The tribunal's order, there is nothing wrong. It was before you. The rejection of 5-3-25 was before you. It was before the tribunal, not challenged. Tribunal has relied on it. So tribunal's order is perfect.
But the
Does not require any interference whatsoever.
rejection order of the Learned Tribunal, my lord, only relied upon the additional my lord, secretary and also finance department. My lord, this point was never raised that I did not challenge that. My lord, that point was never.
Come to first page of the order, last but 4 lines at page 1.
Yes, ma'am. A copy of the memo dated has been presented by the department. In this memo, the department has given the reasons based on DCRP rule 1971 regarding the such prayer of for condonation cannot be accepted.
One. What about tribunal?
The problem is you are reading here. That is the problem. That is why you are asking him. If you would have read it before, this occasion would not have arisen. Now you have seen that is an unfortunate circumstance.
I was making myself ready. I have seen.
What can be done, sir? You tell us. Just see the mess you have created for her.
Then, my lord, kindly remand it, my lord. Otherwise, my lord.
What leaves, sir, that order, that tribunal's order, relying on this decision which was before you and you did not challenge?
And this order was passed in terms of the order of the tribunal. Then September 2024.
Then, my lord,
You
kindly.
filed the earlier OA. They were directed to consider. They rejected. That rejection was communicated during pendency of the matter, not challenged. Relying on that, the tribunal has rejected. Now what is to be done?
Oh, my lord, the first way, in terms of the first way, the authority taken decision that was challenged before the tribunal. That is page 53. Page 53, the authority rejected, negated my claim. Page 53 was challenged before the tribunal. After filing the original application, the department authority, my lord, submitted this before the tribunal.
Sir, they have reviewed the issue, but in terms of the order passed in the earlier OA itself, just now we have read, you must have read it carefully. In 2-3 minutes, we have been able to see what it is, then you must be knowing.
Last date it was submitted, I could not, my lord, challenge, and tribunal decided it at his own way.
How do we know that? Where have you said in the writ petition that in the last day it was given to you and therefore you could not
It
challenge it?
appears from the order that a copy of the memo dated was presented by the department. That is date
It
of-
does not say was presented by the department today.
because in terms of the earlier direction, this was presented
It was
before the tribunal,
communicated to Sobita Mondal.
and accordingly final decision was
It
taken.
was communicated to Sobita Mondal.
That is on the date of hearing, it was submitted to before the tribunal
On
also.
5th March
Sobita
2025.
Mondal actually, my lord, she is in deathbed. A helpless lady, she is in deathbed. Very ailing condition, she is my lord, almost deathbed.
Nothing can be done for you, sir.
Because, my lord, I should have been, my lord, challenge it if it was served upon before the last date of
The
hearing.
problem is you are making submissions which your client has not stated. Which is you are not, it is not open to the counsel to make out a case which the client has not stated. You can't stand there and make out a case on facts which are not pleaded in the writ petition.
Now, only I am confessing, my lord, on the last date.
You are not confessing. You can't. Did you appear before the tribunal? How can you say this? Has your client said so?
Learned junior appeared.
Then you should have advised him to say that in the writ petition.
And this was communicated by WhatsApp message. Mobile number is mentioned there.
You have messed up this claim.
My lord, kindly come to earlier order, page 60. My lord, earlier order. It has been recorded that Lomasar Learned Department representative submits that in terms of the direction of the tribunal way dated, the department has referred the matter to the finance department requesting the specific reason which is mentioned in memo dated such and such. The LR department, why finance department had refused to accept the prayer of condemnation. Submission is that only after finance department returns the matter with their explanation, then only the department will be in a position to enlighten the reasons for such rejection by the finance department. In view of what has been submitted, let the matter be listed on 21st for 2025. 21st for that makes better. Because in the earlier order, there is no reflection that memo dated 5/3/2025 was. After that order, they have prepared 5/3/2025 and submitted on last date of hearing. And tribunal is running with one. Because only my respectful submission. No, only respect. May I take 1 day, accommodation? Because
One of, on 5th March and I had one at can you see page 64A and
Page,
page 64A, the next page. Shobita Mondol, such and such, phone number and as well also mobile number 9433375353. Contact. Apudi annexed it.
no, how do you say it was served?
I have stated,
Shobita Mondol.
I have stated in paragraph 13.
No, from where can you say that it was served on this? This does not say that there is any service. That phone number and email ID at the top, that is no, that is of the department.
Title of the department.
That is of the department.
No, next page. Next.
And then the last page, it is some Raja Bagh. Who is Raja Bagh?
Representative, department representative, before the tribunal.
Please take your seat.
Copy forwarded to Shobita Mondol.
But that does not mean served. Forwarded does not mean served.
He has not received it, how could he annex? If he has not received
No,
it,
because on that day it has been recorded by the tribunal that it is being placed.
page 58. Ask for that. This is the document. Kindly allow me to challenge this order.
Anyway, now take down.
Kindly come to page 30 by satisfaction 13.
Page.
Paragraph 13, my lord. My satisfaction. Page 13, paragraph 13.
Where does it say when it was served?
No, my lord, it was stated that the impugned order 5/3/2025 was submitted to the tribunal. That was not served me. Kindly come to the paragraph 13.
Then how have you annexed it with the writ petition?
Paragraph 13.
On the date of last date,
Yes, sir.
handed over.
Again, you are making the same submission.
I know. But I could not get any chance because tribunal.
Yes, take down. Our learned counsel for the petitioner and the learned
Item number 4.
My lord, I'm playing for not today, my lord.
Not.
Five.
Some cases club.
Item number 5.
Next.
6.
Number 1. Another matter, WPST 81, where the Paschim Bongo Ayurvedic Parishad challenged the same order.
Where the?
Paschim Bongo Ayurvedic Parishad challenged the same order of the learned tribunal. And my lord, your lordship has, on the last occasion in that matter, WPST 81, your lordship has directed that both the matters to be tagged and my lord, heard as the same order is under challenge. So that being the situation, my lord, your lordship may, my lord, adjourn this.
This has to go with 81.
Yes.
When is 81 fixed?
No, my
has
lord.
not been fixed yet. Your lordship can fix both the items.
At any day, my lord.
Any order has been passed in 81.
Yes, my lord.
Order was
That
passed
order
last
was passed also.
Can we see the order?
1 week after summer vacation.
So it will come.
That WPS number, that is typographical mistake. That's 101, not 100, lordship.
I'm sorry, we can't hear you.
Lordship, that WPS number is 101. That is typographical.
1%, please.
That is typographical mistake. 101 will be there, not 100, your lordship.
Oh, it's filing number 101.
Yes, my lord.
That is the present case.
Lordship.
So there is already an order for listing of the matters together. Yes, we are informed that
No, what I'm saying on the next week.
we can't change the order passed in WPST 81. Please try to understand what we are saying. There is an order to be listed 1 week after the summer vacation. It will come.
Except 19 minutes, on that day, operation is there, medical operation is there. So 18.
That case.
On that, please try to understand what we are saying. You ask your friend, somebody to make a mention on medical, we will not adjourn. Yes.
Careful.
Item number 7.
Item number 7, my lord, I appear for the petitioner, my lord. Yesterday, your lordship grant me leave to move this application, my lord. I have served the copy of the government leader, and my lord, a scan copy has been served on the All India Institute of Medical Sciences, New Delhi. My lord, yesterday itself. My lord, this is the affidavit of service.
So you know, AIMS has also been served.
My lord, by scan, my lord, by Gmail. It's by mail. It has been served, my lord. Yesterday itself at 1 AM.
What is the issue?
Issue before lordship. This is my lord, the petitioner before lordship is my lord, a doctor seeking to participate in a selection process to be conducted by the All India Institute of Medical Sciences, New Delhi. Well, for that, my lord, is a mandatory provision in the advertisement which mentions that I require NOC from my present employer. If I'm a government, semi-government, or my lord, autonomous body, and
Where is the last date for submitting NOC?
my lord, your lordship will find page 35. My lord, this is the advertisement. Page 35. At the top, your lordship will find the advertisement number dated 7/4/2025. My lord, opening date of online application 15/5/2025. Closing date of online application 14/6/2025.
And where is the stipulation that at the time of application NOC has to be submitted?
Yes, my lord, I'm just coming, my lord. What is the last? Page, my lord, 77. In other part also there, this deals with NOC itself. In other part, I can show, my lord, again it says it has to be done, everything is to be completed. Now, my lord, got it, page 77. My lord, Roman 14. Mandatory NOC for employed candidates. Regular candidates currently employed in government, semi-government, quasi-government, government enterprises, and government-funded autonomous institution must submit a no objection certificate from the present employer. Failure to produce the NOC will result in disqualification from the interview process. Upload the NOC with the application. To avoid any delays, candidates are advised to upload the NOC at the time of online registration. Well, this is one part. And my lord, if your lordship also takes page 46. Page 46 once. My lord, I may say 1, 2, 3. My lord, the bullet markings are there in page 46. My lord, up from the top, my lord, third and fourth bullet would be important, my lord. A cutoff date to determine eligibility in terms of the age of the candidates will be the last date of online submission of application. All applicants must note that it is assumed that you are in possession of all the required certificates to substantiate your eligibility on the day of the online application, day by which is required to be submitted at the institute as per validity published in this notice. This includes category certificate, employer NOCs, certificates of educational qualification, experiences. Applicable candidates will submit these and when asked for. My lord, your lordship got it, my lord.
Yes, you are still making the doctors run for these.
Page 3, paragraph 2. He joined the service on 12th of September 2016, and according to the amendment rules, at 5 years service necessary.
My lord, 16, today is 25, 9 years I have served.
No. 5 years.
So 5 years is over in 21.
And it relates to resignation, my lord.
Only subject to the without which to the rights and contents of the government, only issue the no objection certificate for appearing in the exception.
But this is of 5 years.
5 years when he would apply for a resignation.
So how this comes in his way, we are not able to understand.
But if he ultimately selected, he has to apply or voluntary. What about 5 years?
But he has already completed 5 years.
Then, Malad, if any disciplinary proceedings or
That is nowhere. That is something futuristic. That is not today only NOC is required.
only he is allowed to appear in the exemption without which the rights and contents of government if he is selected.
Correct. So why are you not giving the NOC?
NOC will be on spot applying the exemption.
Then give only for that.
Don't take it otherwise it's a consent. My suggestion.
No, we are not asking your consent. We are asking why it is being done in every case. Why all the doctors have to come to the High Court for this? And why an individual order has to be passed for every doctor? Why there is no policy of litigation in the state government? Your litigation is also funded by public money.
Yes.
There must be some policy of litigation.
Chief Secretary Mr. Dr. H.K. Dwivedi was that we have notification issued long before that until the matter is disposed of by the Supreme Court.
So any matter in this regard is pending before the Supreme Court. Then you have complied with the other orders. Where is the question of Supreme Court? If you had not complied with the earlier order, then there would be an issue that unless it is decided by the Supreme Court, we have to contest. That's not the situation. In some cases, you are granting the NOC without court order. In some cases, you are granting it after court order. And in some cases, you are just arbitrarily just making them run.
There's no rejection.
There is no rejection.
Nothing, my lord. 13.5 I made the application, my lord. I waited till.
How long you will take, sir? 13.5? How long you will take?
The director department because West Bengal Medical Education.
What has happened? The tribunal has not fixed a date.
The tribunal fixed the date on 18th.
18. And the last day is tomorrow.
Tomorrow, my lord, 14th is the last day by which I have to submit the NOC. But I have submitted, I've uploaded my file that.
Who knows what will happen, but at least he should participate. Whether he will be selected, not selected. We do not know whether you will give him he is eligible for resignation. All that will come later. But why NOC is not being given?
The administrator, executive authority, they are in that question.
Huh?
That they are in the High Court. The state.
No, they are here through you. There is no distinct identity between you and them. Who is the competent person to issue the NOC?
Principal secretary.
Who is representing the aims?
But I have served them director, but although I have no grievance against him, so when I took subject lordship, I have no grievance. But I have made them party as because I have relying on their documents. I have to make them party. I have served them. I have no grievance. AIMS has not done anything against them.
The AIMS till Monday or Tuesday.
AIMS is not before us. What can we do? You should have asked somebody to appear. When he is a party, you can't say that he is not required. I have no grievance. Then don't make him a party.
I have served them a lot on yesterday at 1 o'clock. The Lordship will find the mail report is there.
Therefore, we are asking you who normally represents the aims. Somebody must be representing them. You have filed so many cases.
In case of I asked Ms. Shushmita Dr. Sen, she appears for AIMS Kollani. I said whether he will appear. She said no, I can appear for AIMS Kollani, but
this is for
AIMS New Delhi.
This is for AIMS New Delhi.
I can take instruction from my lord, office of the additional solicitor general, my lord, but I do not know whether he can even.
What shall I do? AIMS has an independent body. I cannot impress upon them. That has to be done in accordance with law.
No. We are not asking you to do anything. We are only asking who has to appear.
For AIMS.
Yes.
AIMS New Delhi.
New Delhi. New Delhi, possibly they have a separate panel. I shall have to ask that.
Can we be informed before rising for recess?
Whether I can ask.
Can you please see what can be done? If somebody is here, then ask him to come, him or her, whoever it is. Because some order has to be passed. Why do you wait till the last day to make it?
Whether they have been served, I don't
No, he says he has sent by email. He has sent by email.
Active services there, my lord, it sent on 1:09 PM yesterday.
know, difficulty has arisen that the appellate side or the original side rules are not amended. Now the email service, online service are being effected. If somebody or the officer interested does not look at the email, it has to be done, hard copy has to be served. That is the rule.
Correct. But as of today, a rule is only an handmaiden of justice. You know the settled proposition of law. So if there is a email in the inbox of the concerned person, and if you tell him to open it and if he refuses to, can he do so?
That apart, there is a provision.
So let us see that.
Order 5 of the civil procedure.
That's why we are saying, just let us see who appears.
I-
Better sense will prevail. At least they will go through the petition and whatever, because we don't want that he should miss this opportunity.
let me see. I shall try.
Try before, if we can get it before rising for lunch, that will be very kind of you.
I shall try.
Yes. Okay. Yeah.
Item number 8. Nine. Item number 9.
Last occasion, your lordship heard this matter. my lord,
In
on
item number 9, I'm for the respondent applicants, and in item number 10, I'm for the writ petitioners. I'm led by Mr. Mojumdar. Show Mojumdar.
my lord, 1st December 2021, my lord, Divisional Railway Manager, my lord, Katihar, issued notification for selection of the, my lord, post of good guards, 15%, my lord, LDC quota. Then, my lord, written examination was held, and my lord, panel was prepared. Finally, my lord, selected candidates sent to the training, my lord, 50 days training, which start from, my lord, 20 March 2023 for 50 days. And my lord, 17 April, my lord, as per my lord, advice of the my lord, vigilance, our selection process was entire, my lord, cancelled. My lord, this respondent applicant, my lord, challenge that my lord, cancellation order before the Central Administrative Tribunal filing OA application. And my lord, that OA application opportunity was liberty was given to the applicant to file a representation before the respondent authority, and finally, my lord, respondent authority pass an regime order after giving opportunity hearing all the applicants. That regime order was challenged before the second OA application, and that was finally decided by the tribunal, my lord, 14 May 2024, setting aside the, my lord, regime order. We are challenging that, my lord, order passed by the tribunal 14 May 2024. Then, my lord, last occasion, my lord, I am showing, my lord, Master Circular 31, my lord, clause 13, and my lord, RB 228, and my lord, one circular, my lord, your lordship wanted, my lord, that day, my lord, RB 192 of 2019. My lord, I am placing, my lord, this.
Which shows, my lord, cancellation of the selection after declaring a due notice given to the candidates declared selected. My lord, a reply, my lord, filed by the respondent authority, my lord. We are before the tribunal, my lord. We start from, my lord, page 112. Reply filed before the, my lord, tribunal. Start from, my lord, 112. My lord, page. Yes. My lord, page 116, my lord. Page 116. My lord, where, my lord, stated by the respondent that notice was given, and copy of the notice is, my lord, page 120, my lord. 12 April 2023. 120, 120, my lord, page number. This is the, my lord, notice prior to, my lord, cancellation of the selection. 12 April 2023. And panel was, my lord, cancelled 17 April 2023. And, my lord, before the tribunal, my lord, on the copy of the reply, my lord, we are, my lord, stated that as per, my lord, advice of the vigilance department, the conducted investigation, and according to advice of the vigilance, the written test has been cancelled after giving notice to the applicants, and fresh written test will be conducted. So before the, my lord, tribunal, my lord, this was disclosed, but report was not placed, vigilance report, but facts was stated before the tribunal that as per vigilance advice, selection process was cancelled. And notice was, my lord, also given, my lord, 12 April. And, my lord, not only that, my lord, when the, my lord, cancellation was challenged before the first OA application, that, my lord, applicant was liberty was given to face representation before the respondent authority. And, my lord, after giving opportunity hearing all the applicants, then, my lord, a speaking order was passed. And that speaking order was challenged by the second OA application. Speaking order was page, my lord, 70, my lord. 70. That speaking was challenged before the second OA application, and order was passed 14 May 2024. That is start from page 121. 124 minutes start. 125. Well, Lord, that a reply before the tribunal, they have stated, and copy of the notice was enclosed the copy of the reply. But that period of time, page 116 reply start from 112, 116 kindly see. Paragraph 15 of the reply. With regard to the statement, order of notification, promotion to appointment relation should be cancelled as soon as brought to the notice of the appointing authority that such resulted factual according to subject selection found erroneous, cancel competent authority. One notice was given to applicant prior cancellation of the said panel. Last line of the paragraph 15. And that copy was they not so they are not stated that not they are saying that notice was not served. But copy of the reply before the tribunal that is stated. That's true. Thereafter, when the speaking order was no, when they preferred the first OA application, tribunal directed them to approach before the respondent authority by fresh representation. That representation was considered opportunity of hearing given to the all the applicants, and then speaking order was passed, and that order was challenged by second OA application. Which order we have? Yes. Speaking order. The cancellation of selection of the following due process and authority next DRM had decided cancellation. Therefore, question of continuance of the applicant training and post of the goods does not arise. In terms of the Master Circular 31 and IRM volume para 200 and were directed to return back the candidate their headquarters by later dated article pursuant to the order of the speaking order, that was not written, that notice was served. They have they are not denied that, no, they are, they are, they are, yes. No, this speaking order, they are not denied that their opportunity hearing was not given. They are challenging the initial cancellation of 17 April when they are in the training. They are, yes, that is they are not denied. Opportunity of hearing this speaking order, they are not.
On the first occasion, directed a representation to be made. We made the representation, and then the order came.
The factual assertions you should not be making dehouse the pleadings. That is not appreciated by us at all. You are saying that is not in dispute. They have appeared, they have been heard. Show us from the records.
Order, my lord, does not show that the opportunity.
You said they have accepted. Where they have accepted? Don't make misleading statement of facts. That's not expected from an advocate. Be clear on the facts.
My lord, impugned order, my lord.
You may make a submission contrary to record. Ultimately, it will be detected.
I am saying, my lord.
You are saying it is accepted. They have never disputed.
Reply, my lord, filed by the tribunal that I have stated, my lord.
No, you said it is accepted. That was not in dispute. They have only challenged the earlier order. Where it is accepted, show us. This is the most unfortunate way of making an argument. Misleading the court is the most unfortunate way of making an argument. There is no such acceptance. We have just asked them. They say one representation was given and thereafter this order has come. You are saying they have been heard, their case was considered, a speaking order, not, and it is all accepted. They have never challenged this. They are only challenging the initial rejection. The full. This 23.523 was not impugned in the way. Now come to paragraph 1.7 of the impugned order. Hence, being agreed by the order of cancellation of the select panel and rejection of representation dated 23.523, OA has been filed. They have made a specific submission before the tribunal that there is no compliance with natural justice, no notice. And you are saying this is not in dispute, it is accepted. And where is was the vigilance report produced before the tribunal?
What will not produce, my lord. Last occasion I produced before your lordship.
Oh.
Lordship.
Nothing.
One second, my lord, your lordship see the report.
24 candidates are taken as per the report. How many persons? You have also challenged the tribunal's order.
It's not, although not very necessary for us, but still not, since in view of the findings in paragraphs 12 and 13, which I placed before your lordship yesterday, day before yesterday.
12 and 13.
It's
That was a non-issue altogether.
29 of the month.
And what does 228 say? Rule 228, is it on record? Rule 228 of IREM, Indian Railway Establishment Manual.
Classification, my lord, I have handed over.
You have given us.
Kindly permit us to place not this compilation so that it may be convenient for your lordships.
Classification আমি hand.
That's page 1 of the compilation.
Is this to be guided by the letter of 23/7/54? You see at page 2 of your compilation,
My lord.
the right column, top paragraph.
Yes. Who has been erroneously promoted and appointed to a post in a substantive capacity, procedure prescribed in board's letter of 54 for rescinding the irregular confirmation of a railway servant should be followed, and only thereafter the railway servant concerned should be brought down to the position which he would have held, but for the erroneous promotion appointment by, probably this is in furtherance to 54, but not, please have a look at the left hand column. Now this consists of two situations. One, when a person has not been promoted at all because of administrative error, and two, where a person has been promoted but not on the date from which he would have been promoted, but for the administrative error. So para 228 of the manual was taking care of these two situations. And
no, but para 228 continues till that paragraph that we have just showed.
Yes, now I'm not.
It is continuation of
Pursuance of 1987 edition, the following provision shall govern the pay and increments of the railway servant whose promotions or appointments in a substantive or officiating capacity to a post is later found to be erroneous on the basis of facts. The orders of notification of promotion or appointment of a railway servant should be cancelled as soon as it is brought to the notice of the appointing authority that such a promotion or appointment has resulted from factual error, and the railway servant concerned should immediately on such cancellation be brought to the position which he would have held but for the incorrect orders of promotion or appointment. In the case, however, of a railway servant who has been erroneously promoted and appointed to a post in a substantive capacity, procedure prescribed in 1954 for rescinding the irregular confirmation of a railway servant should be followed, and only thereafter the railway servant concerned should be brought down to the position which he would have held but for the erroneous promotion or appointment by the issue of orders as mentioned above. Service rendered by the railway servant concerned in the post to which he was wrongly promoted as a result of the error should not be reckoned for the purpose of increments or for any other purpose in that grade or post to which he would not normally be entitled, but for the erroneous promotion or appointment.
So this 1 and 2 does not apply here, what you have read.
But 1 and 2, probably, please come to the first page, the last paragraph.
Yes.
228, the beginning, the caption of 228.
Yes.
Begins with the subject heading erroneous promotions.
Yes.
Sometimes due to administrative errors. Now, that's the language employed by the authorities while cancelling the process. Staff are overlooked for promotion to higher grades. Could either be on account of wrong assignment of relative seniority of the eligible staff or full facts not being placed before the competent authority at the time of ordering promotion or some other reasons. Broadly, loss of seniority due to administrative errors can be of two types. So, three types of situations not contemplated. One, loss of seniority. Number two, eligible staff not being placed before the competent authority. Third is a residuary power.
Yes.
Now, 1 and 2 deals with the first situation, lack of seniority or a erroneous leaving out of a person from the zone of consideration. Each such case should be dealt with on its merits. The staff who have lost promotion on account of administrative error. So that's how the 228 is qualified.
But where is the loss of seniority?
It's not, in my case, it's not a case of loss of seniority.
Therefore,
it's a completely perverse conclusion arrived at by the authorities when they employ 228 for the purpose of cancelling the promotion.
we thought that you were also asking them to comply with 228.
But I said that if this is not a case of tainted versus untainted candidates to be segregated and the authority has not placed any material on record, in the teeth of the findings at paragraph 12 and 13 of the learned tribunal's order, it is an exercise which is not required to be gone into so as to delay the process any further. That's the scope of
but then 12 and 13 says that natural justice is required to be complied. What does that mean? Effectively, it means the same thing. If natural justice is compliant, the tainted and untainted will be segregated automatically.
12 and 13 would come into play in a situation where, suppose there is a case of possibility of differentiation between a tainted and an untainted candidate. Now, before the tribunal, The authorities come up with a case that there was a vigilance angle or vigilance report. Nothing of that sort. But in one of the judgments passed by this honorable bench, your lordship had elaborately dealt with Rule 12 of the Administrative Tribunal's Procedural Rules of 1987 and explained this against the writ petitioner in that case, who was an employee concerned, to say what is the scope of a reply to be filed before the tribunal. And this is also apropos 1964 Supreme Court 477, that celebrated judgment, the scope of certiorari.
No, but the fact remains that they have, whether it is correct, incorrect, we don't know. But they have acted on the basis of a vigilance report. That vigilance report finds some irregularity. And on that basis, that initiated on a complaint by some of the candidates. What is the irregularity? You don't know till date. Notice is nothing. It just says that vigilance has told us. So we are going to, we propose to cancel it, and that is all. So if there is an irregularity or any vigilance issue arising, should they not take it to the conclusion, or can it be overlooked only because the process has crossed to a particular stage?
No, not if there is an irregularity, if there is an illegality, it can always be undone.
Correct.
But there can be no second thought on that.
Yes.
Now, not here is a case where the authorities were called upon to justify their action. But I don't go to the extent of saying that the order on the impugned order on the face of it could not stand the test of law. It's an wholly unreasoned order. But then the matter would have been remanded for the second time before the authority. So the tribunal had called upon the authorities to explain their position. Why have you done so? If I may put it my case in this way. The authorities say the vigilance had told me, therefore I have done this. Nothing on record placed before the tribunal, and the tribunal categorically returns a finding in paragraphs 12 and 13, no material placed despite opportunities. That's possibly the intent of the tribunal's order. And that's exactly the duty cast upon the respondents in terms of Rule 12 of the
Tribunal has proceeded on the ground that the order is not preceded by procedural fairness. It does not say that there is no basis. It says procedural fairness has not been complied with.
If your lordship may kindly allow me to place note paragraphs 12 and 13 once again.
Yes.
I'm sorry, 10.3 first and then paragraph 12, 13. 10.3 first at page, internal page 24. While rejecting the representation of 23rd of May 23, the respondents maintained their stand that panel has been cancelled on administrative account, and in terms of provisions of Master Circular 31, the same has been cancelled. That's the stand. Now, please come to the next, the sub-paragraph. At this stage, it is apt to mention that in reply to OA, the respondents have not placed on record any material to establish any irregularities or malpractice had occurred during the selection process, that too the applicants are as such responsible and liable for any alleged irregularities or malpractice, nor the vigilance report, if any, which can justify their stand. Therefore, the reason offered in the impugned order for cancellation of approved panel for selection to the post of goods guard dated 22 does not seem to be convincing enough in absence of any supportive material to sustain the stand of the respondents. Now, that's the scope of my writ petition. If you have come to a finding of this nature, then why should you again send it or delay the process? Now, please come to paragraphs 12 and 13. Yes, I'm sorry. Paragraph 11.1 at page 26. It can be seen that in the aforesaid letter of 12th of April 23 issued by the office respondent had nowhere stated or mentioned within what time the selected candidates shall have to submit their representation in respect to proposed cancellation of selection to the post of goods guard. Further, it can be seen that though in the subject of the said letter it is stated that notice of proposed cancellation of selection result dated 8th of December 22, but in the middle portion of the letter, the respondents have only mentioned their decision for cancellation of the select panel based on vigilance report. It does not reveal that against proposed action of cancellation of select list, any specific time limit has been granted to the selected candidates to submit their representation. Neither copy of the vigilance report has been placed on record, nor the same has been supplied to the applicants to verify whether any irregularities or malpractice had at all been taken place on the part of the selected candidates. Then paragraph 12. After considering the pleadings and arguments placed before us, we find force in the submission of the learned counsel for the applicant that undisputedly the respondents have not placed any material on record whereby involvement of the applicants in any kind of malpractice or irregularities could be established. Neither the applicants were supplied any material nor served copy of notice as claimed by the respondents. Had it been so, the applicants could have rebutted those allegations. Hence, they have been deprived of fair opportunity of hearing or representation before cancellation of their selection process. In view of the aforesaid facts and circumstances, it is clear that the applicant participated in the examination, competent authority declared them successful in the said examination, and based on the said result, their name appeared in the approved select lists published by the competent authority. Only thereafter, the competent authority deem it appropriate to send them for a requisite training for promotion to the post of goods guard, and as such, the applicants were undergoing training with effect from 20th of March 23 at the training institute. Therefore, in our considered view, right to legitimate expectation has accrued in favor of the applicants herein. It is not the case of the respondents that applicants in any way influenced the selection process. Thus, it emerges from the record that respondents have not acted reasonably or have granted fair opportunity to the applicants herein, and under their objections and explanations before taking the harsh action of cancelling the selection list, which includes the names of the applicants herein. Then paragraph 13 at page 29. In the present case, as noted herein above, the records reveal that before cancellation of approved select list, the respondents have not been granted due opportunity to the selected candidates, which includes the applicants herein. We are of the considered opinion that the respondents have passed the impugned order in an unreasonable manner or unfair manner, which is not in consonance with the principle of natural justice, nor it is passed in terms of the note below para 228.2 of the IREM volume 1, as well as law laid down by the Honorable Apex Court, as well as the order passed by this tribunal in identical cases, which are referred herein above. Hence, in light of the said dictum and discussions made herein above, the impugned administrative action of 2023, whereby the respondent number 3 has cancelled the select list and the impugned speaking order suffers from legal infirmities and unreasonableness, accordingly the same is quashed and set aside. In similar circumstances, when it came to a selection process in Guwahati, which will appear from page 10 of the impugned order, of the order passed by the learned tribunal. Of course, this is not relating to the same selection process. Similar posts are different selection process. Please come to page 10, paragraph 2.6. Further, learned counsel submits that in compliance of the order passed by CAT Guwahati bench as referred to above, the office of DRM, via office order dated 27 February 23, passed an order to the effect that the impaneled candidates are entitled to be promoted to the cadre of goods guard in level 5 on the basis of selected panel published via office memorandum of 2nd July 2021 against 15% LDC. By referring to the same, learned counsel would argue that in the present case, the Katihar division failed to comply with instructions contained in 2019 RB, and the order passed by Guwahati bench referred herein above is squarely applicable to the facts of the present case. Thus, the impugned order is required to be quashed and set aside. But what was the
how that applies to this case? We have read this, but it is not clear.
It was they had complied with an order of quashment in the first instance, although it does not pertain to the same selection process, but similar post, similar grounds for cancellation.
It doesn't appear from this.
Please come to whatever is there is at page in 9. Paragraph 2.4. And the Guwahati bench order proceeding
There
is
it was on account of non-compliance with the procedure. Here you are saying that there is a finding that not only procedure has been violated, but there is no basis.
No basis.
But you can't say there is no basis. There is no basis communicated.
Now, when the action of an authority is challenged or not called into a question in a court of law, not only it's the well celebrated, it's a well propounded principle that it has to come up with reasons with materials, but it's also the requirement of Rule 12. And if I may just read that portion of Rule 12 of the Administrative Tribunal Procedural Rules, it says not how a reply has to be filed, and that's not the. Otherwise, how does a court decide a matter? Merely by saying that there is an administrative reason for the purpose of cancellation and there is a vigilance report.
So we appreciate what you are saying, but
I just read it for your lordship's kind consideration. There is one copy, lordships may kindly share.
yes, we should have the administrative tribunals. Administrative Tribunals Act. Administrative Tribunals. We have it.
The second copy. The heading of the rule is filing of reply and other documents by the respondents. Each respondent intending to contest the application shall file in triplicate the reply to the application and the documents relied upon in paper book form with the registry within 1 month. In the reply filed under sub-rule 1, the respondent shall specifically admit, deny or explain the facts. Explain the facts stated by the applicant in his application and may also state such additional facts as may be found necessary for the just decision of the case. It shall be signed and verified as a written statement by the respondent or any other person duly authorized by him in writing in the same manner as provided for in Order 6, Rule 15 of the Code of Civil Procedure 1908. When your lordships are exercising jurisdiction in 226, your lordships are really exercising certiorari jurisdiction in these types of matters. Please see sub-rule 3 now. The documents referred to in sub-rule 3, it should be 2, shall also be filed along with the reply. The authorities had opportunity twice. On the first occasion when it was sent on remand, and the second occasion when the court was itself examining.
The tribunal could have directed them to give the vigilance report, because the rule says as may be necessary for a just adjudication.
Yeah.
If the tribunal wanted, it could have directed them that don't just say vigilance, show us what it is. The tribunal did not ask for it. The tribunal said, well, whatever it is, you have not complied with any procedural fairness. There is no notice, there is no hearing. On that basis, they have proceeded. That is why it has left the issue to be decided. That if there is someone tainted, untainted, you may do it.
Yes.
So Rule 12, we understand what you are saying, but it does not obligate the respondents to come out with everything which they don't want to come out with.
Yes, then why should our litigants suffer?
That is correct. But then the point is, you could have made it an issue, or the tribunal could have directed that, no, you show us, give us the vigilance report.
The language employed in sub-rule 3 of Rule 12 is,
yes,
the documents referred to,
yes,
shall also be filed.
Yes.
Along with the reply and the same shall be marked.
Correct. So they have chosen not to file it.
So the
Rule 2 says that in reply the respondent shall specifically admit, deny or explain the facts stated by the applicant in his application, and may also state such additional facts as may be found necessary for such. So who will find it necessary? Not the respondent.
So
the tribunal will find it.
No, yes.
The tribunal will find it necessary.
Please see the language. The respondent shall specifically deny so and may also state such additional facts.
Correct.
So the duty is on the
may. Yes.
May. Number when it chooses to exercise this,
yes,
and says that this is an additional fact which requires consideration, then 3 steps in to cast them with an obligation to rely on the document.
But then that they have not placed it cannot be presumed that now they have nothing to say.
I don't say that they didn't have anything. Nobody has seen the vigilance report. Nothing has been.
We don't want to take cognizance of it, but we have seen it. He has just now handed over. We are not going to take cognizance of this because it was not before the tribunal. But so the tribunal has said that, look, you just say vigilance. What is there, you don't tell us. Therefore, there is no basis. Thereafter, even if it is 228 requires a notice and hearing and all that, you have not done. So therefore, we are allowing you to go ahead with that process.
Yes.
You cannot say that they are to be precluded from inquiring into the issue.
No, there are 2 parts. One is in the teeth of paragraphs 10 and 12, whether that conclusion part should sustain, Even if it is sustained.
If the the tribunal is the author of the order, it itself records that there is nothing brought on record, but leaves it open.
It left it
So
open to
therefore,
segregate.
if it has left it open, then can you say that no, it cannot be left open? Because you have challenged, therefore we are asking you. You have
Yes,
challenged.
to that extent, I may, as an officer of court, not raise a voice. Because
we have understood. We are just trying to understand this circumstance. Because if there is an illegality, if it is detected 2 years after they have been promoted, still it can be done.
If there is a fraud committed, that can be unraveled
At any time, it can be done. So, something else you want to show?
No, I was only on this. Not if there is an illegality, that can be remedied.
Correct.
No doubt. Not if there is a segregation required to be made, that has to be made.
But it has to be preceded by a proper notice. Everybody has to be informed what is being looked into. When only everybody is allowed an opportunity to respond, then they may proceed.
That if your lordships kindly recollect that observation in Sayyid Yaqub, in exercise of certiorari jurisdiction, what a court normally does. It's really an error of law apparent on the face of the record, which is normally interfered.
Certify the records. That is the concept of certiorari.
Certify and quash an order in the event of an error of law apparent on the face of the record. Now, not in the facts of the case vis-a-vis the.
But do we exercise certiorari jurisdiction? Article 226 very consciously says writs or orders in the nature of.
In the nature.
We do not have the prerogative writ jurisdiction which
the English courts used to.
Therefore, there is a slight distinction.
But not still then not our honorable
principles more or less same apply, but there is a distinction.
But probably in the light of Article 225, which has retained the power exercisable by the English courts in the 226 jurisdiction,
but
therefore not
226 is very careful in saying that these are writ orders or directions in the nature of. They are not writs of mandamus and.
So not what was exercisable by the Crown is still retained in 225 with the additional power exercisable by courts in exercise of 226 jurisdiction.
You are assailing the directions also. Are you assailing the tribunal's direction also? Direction contained in 13.1. Please read. It is not a leave given to you. It is not an opportunity. It is a direction.
As this petition is pending before your lordship, no step has been taken till date. Or no steps has been taken till date.
No. Are you want to comply with this, or you are challenging this direction also? That is what we are asking you, because you have assailed the order. You have assailed the order of the tribunal.
Yes, Lord.
The order contains a direction to you, which is stated in so many words in 13.1. Are you assailing this direction, or you are not assailing this direction? You have not said that the writ petition is filed limited to this extent and that extent. You are assailing the entire order.
Yes, Lord.
So 13.1, there is a direction.
Yes. I also challenging this part also to set us.
So you don't want to inquire. You don't want to inquire.
But want to inquire, my lord. This, my lord, tainted and non-tainted.
Sir, we ask you, please read 13.1 first, then address us.
This is not possible, my lord. As per instruction, they are not.
This cannot be done. You have said so in the writ petition.
My lord, we are challenging the entire order.
Why this is not possible? Where have you said in the writ petition?
Railway challenging the entire order, my lord, not.
Where have you said that it is not possible?
Here, my lord.
So your challenge is limited to paragraph 10.3 and paragraph 12, and their challenge is to the whole order.
But please see the grounds at page 15.
Page
15 of their writ petition.
yes. We'll pass the order in the next week. Anything else you want to say? You have said that notice was given. You have said that hearing was given. Procedural compliance is there. You have said that there are justifiable grounds.
As per
This is
reply, my lord, filed by the tribunal, where stated that notice has been served. My lord.
all that you have already that you have shown.
And my lord, last occasion, my lord, I have placed one. MAT number 95 of 2009. Dileswar Kumar and other versus Union of India.
This
Railway Protection Force, my lord, promotional, my lord, selection.
we have found one copy, but we can't.
Paragraph 7, my lord, stated entire, my lord, training was completed. Then, my lord, as per my lord, vigilance report, my lord, selection was. cancelled.
So as of today, you are on the promoted post or you are not on the promoted?
So that training has been cancelled and we have reverted back to the places where we were.
Paragraph, we have only one copy, sir.
Copy, my lord, I had.
You have an extra copy. After that, there will be a copy with you. Then refer to it, then you give us paragraph.
Paragraph 7, my lord, stated there, go to, my lord, course of training. Then, my lord, paragraph, my lord, 10 was completed successfully, my lord. They are paid to promotion, the promotional post of assistant sub inspector. Then, my lord, paragraph 10, my lord, for cancelling the entire selection process on the basis of the vigilance report. Paragraph 26. Sir. Paragraph 28, my lord, the division bench hold that we are opinion that competent authority has rightly decided to cancel the, my lord, selection process. Detection of serious irregularities specifically mentioned in the vigilance report. That is the, my lord, opinion of the, my lord, division bench judge.
Paragraph
8, page 12 of the judgment. Paragraph 28. We are of the opinion that
yes, the court was rightly of that opinion. Whether we are to take such opinion, that is the point. You read this paragraph 28, you before that you read paragraph 20. Then you read paragraph 28.
here, my lord, vigilance report was placed before the court. Read that.
Read paragraph 20. You, in this case, you have produced nothing. Just see what has been produced in that case.
Reply, they have stated that as per vigilance report, but report was not placed. That is more.
We are just taking note of your submissions. Yes.
And apart from that compilation pages 1 and 2, your lordships may also take note of page 19. This is probably the document your lordships were looking for on the last occasion.
19.
1/9 of the compilation.
Yes. Just take the submissions. The first writ petition is theirs.
There.
The writ petition within bracket WPCT 204 of 24
But if it is outside the league, concerned additional solicitor generals or deputy solicitor generals of respective courts may be approached on their sanction, we can appear. That is the instruction.
So do you, can you represent them today or you cannot?
No, I have no paper, how can I? Without instruction from them, I will have to talk to them. Whether this is a question, whether limited to a very.
Actually, time is of essence in the present matter because as per your advertisement, he is to submit the NOC along with the application at the time of filing the application online, and the last date perhaps is tomorrow. NOC has not been issued by them.
No, that possibly has to be done by other department, not by the AIMS Kolkata.
NOC has to be issued by the state government.
Correct. AIMS, the NOC has not been issued by them yet.
So I shall try even after 2 o'clock to talk to them, and I shall come back. Possibly your lawsuits have a different bench, separate bench.
No, but we can sit. We can sit. Right now, we can say that we'll reassemble at 3.
At 3.
Yes.
I shall try to get it, come back with
you. Also, Mr. Mukherjee, you find out provisional NOC should be issued.
Can you do one thing?
Yes.
Subject to my lord's approval, can you do not?
Because see, even if they issue a provisional NOC, unless you agree to accept or we direct you to accept the provisional NOC, it will be a futile exercise. We don't know whether he will compete, what will his position, but whether he.
I shall try to come back.
May I suggest one thing?
Yes.
Subject to the approval of Mr. Chakraborty, can you pass an order? The Secretary of the Department issue a professional certificate, if possible by today or by 4 o'clock. If it is order is supplied to me immediately, I can.
But still, provisional certificate, whether they will accept.
No, that would be the.
Their advertisement says to make a application with NOC, not provisional NOC.
That has been mentioned. Or
there is no provision for a provisional certificate. Then they may not accept.
So therefore, either we have to direct, if we want to direct, or they have to say that yes, we will accept his candidature based on provisional in view of the court's order.
I shall try to come back at
Please try to resolve because it is a question of his career and he is not at fault. He has made the application on 13/5 and still nothing has been done. So just find out what can be done. We'll reassemble.
At 3 o'clock you lost it.
At 3:15. Yes.
I have one more prayer.
Yes.
Is for the respondents. Then extremely urgent matter. I have been asked by the Secretary to the Ministry of Environment yesterday in the evening.
Ministry of
Environment. And Forest and Tribal Affairs. Yesterday in the evening to appear in a matter in item number 13.
13.
13. Now here what happened? The question arose as to grant of certain benefits regarding promotion to those persons who have came before the tribunal that they are discriminated against, others who have been granted.
In the matter of?
The matter of promotion.
Promotion.
Retrospective effect of certain benefits. Now
you are for the Union of India.
We are for the Union. We are for the petition. Mr. Ghosh has argued at length on the merit. But now, then I understand when I find from the records. He has argued, but the contempt rule has been issued by the Central Administrative Tribunal fixing 17th of June at the first hour.
We'll take it up on Monday. Don't worry.
No, may I just make one
humble
prayer? Because this is asking the Secretary, Department of Environment.
Monday is 16th, sir.
But he has to, Secretary of Government of India has to take some preparation for coming. If he lost him on Wednesday, day before yesterday, in one of the matters I was present, that compassionate appointment matter, Indrajit Dasgupta advocate was arguing. In a similar situation, your losses have been pleased to give relief, grant stay of the contempt proceeding.
If they appear before the tribunal.
I am submitting only on this. Kindly appreciate.
So we'll take it up.
Large number of Supreme Court judgments.
We'll take up on 16th. Or you wait. There's after only 2 cases left. There's only 2 more cases.
I am praying subject to lordship's correction.
No, therefore we are saying, let them call.
No, yes.
Wait, yes, call the list.
Item 11.
No, before opening of this case, my lord, this is a contempt application. Order
This,
was
this one,
yes, order was passed by your lordship. The day before yesterday, the department contacted me. They informed me they have decided they have filed the sent the file to the Supreme Court for filing SLP. But immediately I directed them, if you give an undertaking to not to proceed with the SLP, I will pray for some time to comply the court's order.
oh, we have not understood. You are approaching
Passed by the Supreme Court
for,
salary from 2013.
okay.
Then murder of 2023. Now, without initiating any proceedings, but salary was stopped. Now, your lordship held that without initiating any proceeding, this cannot be done, pay the salary. Now, within month, no, 6 months. Then murder, they, with the opinion of the runner LR, decided to file an SLP and file was sent to the Delhi. Then murder, they got the information that contempt application filed. Then who told you? The LR gave an opinion. I disagree with the view taken by the LR. Even me, I have undertaken that we will not proceed with the SLP, but then you should give some time to comply the court's order.
A very reasonable stand. How much time?
4 days time may be given.
All right. Can we record this stand? Yes. What is this, madam? What more do you want? What more do you want?
But I have decided,
Yes.
directed them not to proceed with the SLP.
Item 12.
Okay. Is the date on 11th? Then it must be 4 weeks. Here. So here. So instead of 11th, we should have it on 18th. Instead of 11th, make it.
I appear for the petition, but urgency matter, I have told madam, the next matter is very urgent, and your lordship kindly take it upon 18th.
On? Who is for the respondent?
I will.
He is here.
Yes, yeah.
Okay. As spread by petitioner's counsel list on it.
Thirteen.
I appear. Of the bill, but we will only modify it instead of direction. To proceed in But this is of Union of India, Department of Survey of India, against an order passed by the allowing the way and granting benefits to the private respondents as regards antedating of intro situ promotion and flexible complementary scheme with retrospective effect. Now, this was fixation, and the main point was taken by them is that in view of the decision of the Supreme Court and also of Hyderabad Court, some of similarly circumstanced persons have been granted benefit. Why shall they not be granted?
That Murthy case.
He has argued, my lord, for the last. I have come under a compulsion because yesterday in the evening I have been requested. Why? Because during the pendency of the original matter and being heard by your losses from time to time, rule of contempt has been issued against the secretary.
He has put in his best effort, but we have not been convinced.
So that your losses will decide.
All right.
Kindly
Very well, very well, very well. We have understood.
Kindly, may I just make
Yes.
one point? I am just making only one submission.
We have understood.
No, possibly I have not been able to tell that.
All right.
This actually, the law is well settled by the apex court and now this honorable court, that when an original order is appealed against or challenged in a higher forum, no step can be taken for initiation of a contempt proceeding.
And modern foods.
Not that, may I just have the word?
And modern foods judgment, sir. Mere filing of appeal.
No, mere filing of appeal is no stay. But what is the
With regard to contempt jurisdiction, apex court decision, the order should be complied. If the authorities are of the view, they may comply it subject to result, but they can't just sit over it.
Lord, may I just hand over this judgment?
We are going to hear the matter with who is for the response.
Majumdar and Mr. Das.
We'll fix it for.
Yes, kindly give me some opportunity to argue.
Full opportunity.
And kindly can't stay, my lord, of the order.
Has to, if otherwise it will either they stay or they will say whether they want to move further or not.
I don't have any instruction as regards the contempt proceedings in tribunal.
No, my submission.
No, he is saying that the secretary's appearance has been directed.
Probably
Yes, sir. Secretary's appearance.
Tribunal has directed only to implement this order.
left to me, my lord, I am not insisting.
Not
on
a,
the presence of
this is not a personal appearance order is there.
No.
No, rule of contempt has been issued. It is the secretary and the director. Possibly my landman is also not aware. 17th is the date fixed. Last paragraph.
Let it be on Monday.
Yes, there is a direction.
Let it be on Monday, Lordship, can you hear out this matter?
Why Monday?
Cannot be done.
17th is date fixed.
Cannot be done on Monday. Yes. Take down.
Director from.
তেইশে জুন
Item 14.
Lordship, I appear on behalf of the state respondents, Your Lordship. Your Lordship, that
Item 14.
Your Lordship, this is that matter where the petitioner has been seeking adjournment since December 2024, Your Lordship. There's a last chance given.
Number of last chances.
Main order first indicator, first order. Correct. Right thing to do. Same order.
Item 16.
Yeah, I will sit and complete that 163.
My lord, in item number 16, I beg to appear for the petition.
Item 16.
My lord, in item number 16, I beg to appear for the petitioner.
Yes. Next.
Lordship, I am appearing for the petitioner. In item number 16.
Item 17.
My lord,
Put that into echo. Just one check. When it goes to me, you can see it.
My affidavit in reply to the affidavit in opposition filed by the Public Service Commission.
The preliminary issue has to be dealt with first. They are
In the affidavit in opposition that has been filed by the Public Service Commission, they have not raised any maintainability point.
they have already, it is already recorded in the court's order.
It was raised by the.
It's already recorded in the court's order in your presence. What kind of objection you are raising?
The state respondents, till date, they have not filed any affidavit.
Sir, they have already raised the issue of maintainability. We have reserved that issue of maintainability by a order in so many words.
I am not denying that.
Then,
but the state respondents till date, the state respondents are yet to file their affidavit in opposition, and
the state opposition is required.
Yes, ma'am.
And the Public Service Commission is the main answering authority. My allegation is against the Public Service Commission only. They have filed their opposition, and in that opposition, my lord, they have not taken any point regarding maintainability of the.
Again, you are saying the same thing.
I am just apprising the court what the fact.
Why are you apprising? What is the relevance when that issue is very much recorded in the court's order sheet? What is the relevance? Issue of law has to be pleaded in the position once it is already recorded. Why have you not filed the opposition, Mr. Mukherjee? Why have you not filed your opposition? Huh?
7 days.
7 days.
Time was extended.
The
Item number 1.
Lordship, I am for the petitioner. Lordship, the wife is the petitioner before your Lordship. We have filed this contempt application. Lordship, by a judgment, Lordship, dated 12th of March 2025, Lordship, your Lordships granted a decree of dissolution of marriage and directed the husband to pay the wife a sum of rupees 50,000 per month. But since Lordship, he did not pay us anything, Lordship, we were constrained to file this contempt application on 14th of May, Lordship. Thereafter, Lordship, on 25th of May and 8th of June, he has only paid 21,000 rupees each time.
Every month.
Yes, twice. But he was directed.
Instead of 50, he is paying 25. That is what you.
That was the amount he was paying when the appeal was pending. And that too after Lordship.
When the appeal was pending, he was paying 25 or 15.
No, he was paying, Lordship. There was a direction of this honorable court to pay the wife rupees 12,500 and 8,500 for the minor daughter. Total 21,000. So now your Lordship will kindly take up page 38. The order, Lordship, starts from page 20. At page 38, Lordship, paragraph 25.
Let him appear. You serve. Let him.
Unless your Lordship.
Yes. Let the notice be served on the
Item number 1.
My lord, your appellant is before your lordship, only seeking modification on 2 points, my lord.
Modification.
Modification to the order impugned, my lord.
You were the petitioner.
Petitioner appellant before the appellate court, my lord. I we come to the page number 60, my lord, of the application for appropriate order, my lord.
Page number
60.
T. Page number 60 of what?
Of the application, can application number 1 in connection with the review application. Application for appropriate order, my lord.
This is a review application.
My lord. My lord. By the order impugned, my lord, this honorable court has held that I am entitled to get the family pension with effect from 25th February 2013. I am grateful to this honorable court, my lord, but during the pendency of the leave, the respondent have issued a memorandum, memorandum that is annexed at page number 60, my lord. And
number 60 points of law is there.
Of my application 60.
Here of the can.
Of the can.
Can 1 filed in MAT.
No. Can 1 filed in connection with the review application in 2025.
Can 1, there is no can 1 here.
Can.
Review ka can ka hai, ye to MAT ka.
My lord, even then, my lord, kindly come to.
Then come to this, and then if something else is not found, then come to this.
This memorandum is also annexed with the stay application, my lord. I can show from your stay application, my lord.
No, but you are saying that you have filed can in review.
My lord.
When you have filed it?
Date of formation. Oh my God.
And where have you filed it?
The application is filed with along with the memo, my lord. Okay. Date of filing, I can.
Memo.
On 25th of April 2025. 28th of April. It is a form.
We are not asking you the date of affirmation. We are asking you the date of filing.
Filing on the same day. Then, my lord, I have to see the case status. Is it not with the?
Has he served you with a copy?
I have served.
But this is an application for appropriate orders. That is can number 1.
Is
can number
can
1
number
and the
1.
PPO is
It
annexed
is
at
appearing in the cause list, my lord.
PPO is annexed. No, they are searching for it. So what is it you want?
My lord, by that PPO that has been set.
No, we are not rehearing the writ petition.
My lord, I am not seeking for that.
It appears that is the impression we are getting.
This PPO was prepared by the respondent on the basis of some memo.
Why should we look at the PPO? What is the error in the order? What is the error in the order? Show us.
My lord, this PPO has been my lord.
Please show us the error on the. We are not going to look into any document for your asking.
This is connected with the widow pension, my lord.
We are not concerned whether widow pension or family pension.
Unmarried daughter, my lord.
You have to confine yourself to the limits of a review jurisdiction. What is the error? Show us the error from the order.
By this honorable, this impugned order, my lord, the honorable court held that I am entitled to get the family pension with effect of 25th of February 2013, my lord. But no interest has been
with effect from
25th of February 2013, my lord. But no interest has been granted to me, my lord.
Yes.
My lord, in a similar case, my lord,
you are here for interest.
My lord, the Honorable Justice Vishwas has passed an order, my lord. Where has
First come, show us the fact, don't just hand over judgment. Show us where is your prayer in the writ for interest. And where is the submission? You have made any submission? It is recorded in the order.
The writ petition, my lord, or stay petition, my lord.
In
both
the order, where is your submission for interest?
My lord, in the application, my lord, I have made a prayer for that, my lord. Kindly come to the page number. There B and C of the stay application in connection with the appeal, my lord. Page number 41 of the stay application, my lord.
Your CAN is not here. Where have you filed it? Please tell us where you have filed the CAN application.
This is a CAN application in connection with the stay application, my lord.
Can you hear us? Can you hear us?
My lord.
When and where have you filed the CAN application?
Yes, sir.
Filed in the department. There has to be a filing number.
Where is the filing number? Show us.
See the case status, my lord. Impossible for me not to see. My lord, I have to check the date of filing from the case.
But one thing I can tell you, Lordship Malad, he is not aggrieved by this order. Now he is saying that the respondents have not complied, respondents have not given anything. That gives a separate cause of action. How in the review jurisdiction?
No, he is not pressing anything. He is just saying he wants interest.
Interest, my lord.
That is all he is saying.
That he has never submitted. I was there in the appellate court, my lord. He has never submitted. He submitted that it has to be from a specific date, and that was granted to him.
Where is the CAN? Show us what document you are trying to show us. Where is the CAN? When have you filed it?
In April, my lord. So,
in April, very good.
My lord.
Very good.
But my
Why
lord,
don't you say in 2025?
My lord, but
What is this in April? You must be given a filing number.
filing number is CAN1. Then, my lord, I have
If you are not keeping anything, then what can be done for you?
from the case status, I can show you, your lordship.
Huh?
But survey is not from the case status, my lord. I can show, but survey is not working.
So tell us from the case status. Give the date.
Server is not available, my lord. Today. Then, my lord, today adjourn for the day, my lord. So what? Then I ফাইলটা 26 নম্বর কোর্টে দুটোই একসাথে ছিল ঠাকুরদা।
Let us see what he is trying to say.
And appearing in the list, so for that I can কালকে তো ছিল। The review can take it.
Yes, page 60. What is that page 60?
Page 60, my lord. If PPO is issued in terms of the memo number 1184 dated 24th August 2021, deal with memo number 883 dated 12th 11th December. These memo deal with the family pension of the widow, my lord. Since 2023, my lord, I am receiving a widow pension, whereas the fact is that I am the unmarried daughter of the deceased employee. I have annexed the memo page 63. 5.
Right? I think the time of death of his mother. Then it has been given. But uh, did he argue? Sorry. You did not argue for interest.
There was prayer, my lord. In the
There are so many things.
yeah, I have prayed, but
You may have prayed, but you did not argue. Nobody is saying there is no prayer. We have not said that there is no prayer.
before the court, but
You have not argued for interest.
in a similar case, my lord, the
You
court-
have not argued for interest.
my lord, there is a prayer in the state of
There may be.
read petition, and I have argued before.
All right, that we'll consider.
There is a similar.
If
My lord, there is a judgment passed by the Honorable Justice Vishwas in the similar case, my lord, where has the Honorable Justice Vishwas sitting with the Honorable Justice Harish Tandon has granted 7% interest.
yes, because there was an argument for interest. If you don't argue, then where you will get the interest?
My lord,
No, don't say that.
You have not. You have
Don't
not.
say. Don't.
I was there.
Don't.
on the last day,
Don't make incorrect submission. At least one of us is there.
my lord,
Don't make incorrect submission.
I am begging.
Don't make incorrect submission.
I am
Please.
praying from the beginning,
Yes.
my lord, for the interest on the.
You have made a prayer, but you have not argued for the interest.
Page number 7, para number 12, my lord.
Page number 7.
Of, page number 7 of the judgment, my lord, that I am relying upon. Para number 12, my lord. The director of the Pension Provident Fund and Group Insurance, West Bengal, is hereby directed to release the pension in favor of the writ petitioner within a period of 1 month from the date of the communication of this order, together with interest at the rate of 7% per annum on the said areas. So my client will also should be granted such. When I am getting the family pension since area of 2013, my lord. My client is a handicapped aged person, my lord. Both the parents have died. Unmarried daughter. No one except one elder sister. There is no one to take care of her. It is also case of unmarried daughter, my lord. Family pension. That case, my lord.
Yes.
My lord, so far as the interest is concerned, my lord, he has never paid. I was there.
All right. So therefore, he is in review.
He is in review. Can he ask that what he has not asked for?
Tell us why he can't. That is why we are asking you.
Subject to correction, my lord. In a review application, my lord, what is to be considered, my lord?
That is what we are asking you.
He has inserted those prayers, but he has not prayed for it.
That we have already observed.
Yes.
You are just repeating what we have said. Now, why is that a ground for rejection of his review? What is the scope to us? Where is the law?
What is the error apparent on the face of record?
Error apparent,
He
there
is
is
not
a
aggrieved
prayer
by
is-
the order. He is not aggrieved by the order. He is asking for something which he has not prayed there. He is asking the new thing
He
here.
has made a prayer in his application.
He has made a prayer, but he has not pressed that. So I made 10 prayers. I don't praise.
Correct. So now he has realized.
Can he praise in a review application again?
So therefore, we are asking you. Don't ask us.
No, I'm not asking
You are
you.
here
Not
to assist
I'm
us.
asking myself.
Show us the law.
I'm asking myself.
Show us the law that he can't do it. You are saying is not the law. You have to show us. Show us the law.
Lord, I shall. I shall
Come with
bring
it.
that. Because today is the first date, my lord.
So come with it.
Yes.
The learned counsel for the review petitioner.
The respondent to so the widow pension portion should be corrected, my lord. That's my humble submission, my lord. Grateful, my lord.
Item number 3. My lord, this is my application in contempt, rising out of an order passed by Justice Harish Tandon, sitting with my. It's appearing for the first time. And very well. My lord, the order will start at page 57. And it's a long order. It's a judgment of 30 pages or not.
Complied accordingly.
But get it at page 83. The judges just say that the application as filed before the tribunal is allowed. The prayers before the tribunal, my lord will find it page 93.
92.
93. Please sought to issue a mandate directing the respondent authorities to record the name of the petitioner on the record of right. This was a mutation case. LRTT didn't allow it. We came up before this court. Justice, the division bench was pleased to allow it and direct it to be done. They went up on appeal. The Supreme Court, the SLP was dismissed. In spite of the SLP being dismissed, and in spite of our specifically writing asking.
Where is the prayer? Page 93.
The prayers before the trial court, LRT as page 93, number 7. Issue a mandate directing the respondent authorities to record the name of the petitioner and record of right with respect to such and such doubts. And my lord will the order of injunction at D if it is required. judgment order, the operative portion would be at page 83. At page 83, my lord, will just the last paragraph. We have the discussion made here and above. The order of the tribunal is set aside. The application filed before the tribunal stands allowed. After that, the order on the SLP, we'll find at page number 98. No review file, nothing. I have asked by my letters at page at 99 and 102 for compliance, complete silence. Immediately thereafter, everything. 10 months have passed. It's only a ministerial job of recording my name in the record of rights, not yet done.
Where is the communication sent to you?
The communication
Sent by you?
My lord, at page 99, along with a copy of the order of both the LRTT order as well as the division bench judgment.
This is after disposal of the SLP.
This is after. My lord, which see, I have specifically mentioned that at point 5, in appeal filed by the state of West Bengal being SLP number such and such, order passed by Honorable High Court is upheld.
Serve a notice. Same order.
7. I'm extremely grateful your lordship has taken the trouble to again sit at 3:15, my lord.
No.
I occasion to persuade the AIMS Delhi. Stupendous task.
Obviously, that is why
Very short time.
he had the benefit of your presence. Otherwise,
But the instruction is
yes.
WhatsApp I'm reading. This is the regard during the case discussed with. The matter was discussed with professor in charge, faculty cell, and as per discussion with him, him shall accept provisional university issued by the concerned president.
Very well, you give it to him.
By the regular or these are the, let it be on record. This has come in my WhatsApp.
You thank your learned senior.
I blessed him. Itself, my lord, I
Yes.
very grateful to him, my lord. He has taken the trouble also to my lord.
No, we have done nothing. We are supposed to be sitting here. They have done what they are required.
So before passing the order, I have already communicated the secretary and director of medical education, DAV.
So how soon can he get it? Can he get it today?
Very difficult. That's the difficulty.
Tomorrow.
He is busy with the meeting with the CS, chief secretary. But if it is possible by let him go by 4 or 5 o'clock, so that something could be.
We'll say by tomorrow. Get it. Because tomorrow is the last date.
Yeah. May I visit your lordship before receiving the order, so that order can be uploaded immediately.
Oh yes, immediately we will give you.
So that I can forward.
Tomorrow is the second Saturday. My learned friend's office shall remain closed.
No, so that I can immediately by 5 o'clock or 6 o'clock, whatever may be there, so that something could be
The
done.
issue